All right, good morning, everyone, and welcome to the Mandatory Regulatory Compliance Series organized by the UK-Ghana Chamber of Commerce in collaboration with WTS Nobis Fails. Today we have Mrs. Ware, who is our main speaker. But in 2022, July, the Office of the Registrar of Companies was created in line with the New Companies Act. And therefore, there's been a separation or a carve out from the former office of the Registrar General Department. And so today we want to really understand the mandate of the new ORC and some key company law issues bordering on beneficial ownership and other related matters. Mrs. Ware is a well-known, respected company law expert in the country. I call her my mother because she's very responsive. She's a lawyer by profession, a member of the Ghana Bar, over 30 years at the Ghana Bar. She worked with the Attorney General Office and subsequently was sent to the Registrar General's Department, and she's gone through the Registrar General's Department, has risen to the ranks. At some point, she was acting Registrar General, and she became the substantive Registrar General. She's a leading corporate lawyer, and she's credited for the success of the reforms to ease the registration of processes of registering businesses and doing business in Ghana. As you can see, a lot of implementation is going on at the Office of the Registrar General, and she's the one leading the change in terms of digitization of company records, automation and networking of regional offices, decentralization of operations of the office. She's a commissioner of the Securities and Exchange Commission, a member of the Ghana Bar, and Federal of International Women Lawyers Association in Ghana. Mr. Ware, we're happy to have you this morning. And as always, I know you'll give us an insightful presentation. And we have a lot of people online, and you have your audience, Mr. Ware.
Thank you very much, Theophilus. And let me say that I'm very grateful for this nice commendation given to me. It all goes back to the one who created me. That glory goes back to him, because without him, I'll not be where I am today. So thank you very much, all you participants. And I'll try and quickly go through my presentation. And we have the outline. I'm going to be talking about the office, the objects and mandates, the key updates relating to the ORC, the beneficial ownership regime, a brief introduction to the Corporate Insolvency and Restructuring Act. In short, we say SIRA, and then the conclusion. Now, Theo, you said it already. The Office of the Registrar of Companies was separated from the Registrar General's Department based on the Companies Act. And this was a design as far back as 1963 when Gawa, codified the Companies Act. He always wanted there to be a separate office overseeing business and company registration. But at that time, there weren't enough companies that had been, incorporated. And that is how come he sort of put that function under the Registrar General. And no, it's gone all these years. And it was a Registrar General, therefore, overlooked companies, marriages, estates, industrial property rights, everything that Gawa initially didn't want to be lumped up. So when the time came for there to be a repeal of or review of the Companies Act, then the committee of experts thought it would be wise to now carve out this separate office that will be focused only on businesses. And that is how come the Office of the Registrar of Companies has come into being. And so you can see that we are focused and concentrated solely on entity registrations and administration, as well as advancing sound corporate governance principles, transparency, and also the ease of doing business. Now, this office has been set up under this act as a body corporate. We have perpetual succession. It's headed by my good self, the Registrar of Companies, and I'm supposed to be assisted by 2 deputy registrars. The president will appoint them in due course. And so the Registrar General Department is not going to just go away. It still exists. And it will just oversee industrial property rights, registration, administration of estates, and marriages. Luckily, the president has also appointed a new registrar general. So as I went off as registrar general, I'm now the Registrar of Companies. We have one lady, Mrs. Gracie Sahak, who is now overseeing the units under the Registrar General's department. This new office can hold property, enter into any form of contract under any transaction. And we even have the powers to come under the State Lands Act to acquire properties for the office. And this is going to be borne by this office. We have our own seal, Registrar of Companies, Ghana. And most importantly, we have financial autonomy. And you can find this under Section 352 of the Act. For initially, under the Registrar General's Department, we only allow 16% of the internally generated funds. But because of this new act, even though finance was not too excited, they're allowing us to retain all our IGF 100%. And so there's a lot of work to be done with this money. We have to justify being allowed to retain all this money. The office now is no more being overseen by the Minister of Justice, but is overseen by an 11-member governing board consisting of a chairperson, the person of Mr. Seth Asante. In addition, we have a principal state attorney representing the Office of the Attorney General and Minister of Justice. We have a director representing the Ministry of Trade and Industries, a lawyer representing Securities and Exchange Commission, a representative from the Private Enterprise Federation. We have 2 lawyers, actually, over 10 years experience in corporate law practice, representing, with expertise in corporate law practice, being nominated by the president. Then we have a lawyer with 10 years experience in corporate law, representing the Ghana Bar Association. And there's a gentleman from the Institute of Chartered Accountants, Mr. Professor Datiba, Justice Datiba, from the Ghana Association of Restructuring and Insolvency Advisors, in short, GARIA, and my good self. That makes us 11. But this board is there to ensure the proper and effective performance of the functions of the office. Now, the main object of this office is to register and regulate all types of businesses in conformity with this act and other enactments. And so it's not only companies we are administering, we're also administering business names in accordance with the Registration of Business Names Act, 1962, Act 151. We're administering companies already under the Companies Act. We are administering partnerships in accordance with the Incorporated Private Partnerships Act, 1962, Act 152. And lastly, we are also overseeing professional bodies, the registration of professional bodies pursuant to the Professional Bodies Registration Act 1973, NRCD 147, and other professional bodies established by any act of parliament. We also appoint inspectors, the company inspectors. We appoint receivers or managers to ensure the effective compliance in accordance with the act. And we are now, based on this new act, we are now going to have a new unit known as the Insolvency Services Unit or Division. And this is because we are performing the functions of the office as the official liquidator, as well as the regulator of insolvency practitioners. This is a new function entirely. The official liquidator was already there under the Bodies Corporate Official Liquidations Act, but that has been replaced by the Corporate Insolvency and Restructuring Act. I'll talk more of that in my presentation. We also manage the finances and fixed assets of the office, and our main duty is to undertake public education programs to educate the general public, engage in business activities of the operations of companies, partnerships, business names, professional bodies. And so this particular webinar is one of them. Now, I talked of the Corporate Insolvency and Restructuring Act. You can see that it was passed in 2020. It replaced the Bodies Corporate Official Liquidations Act. So it brings in a new regime of a rescue culture, because in the past, we will just incorporate you. If you're not doing well, we'll liquidate you. But now we've brought on involuntary and official liquidations, and we're providing the rescue of businesses that haven't yet reached the point of being closed down. So at that point in time, we can appoint administrators, and they will try and administer the business for some time, possibly look for more funding to prop it up. That's especially the businesses are distressed. We also have, apart from administrators, restructuring insolvency practitioners to restructure the company. And at that point in time, there is going to be a temporary management of the affairs and business of this distressed company. We have to hold in check all these creditors who will be paying for their blood. We try as much as possible to ensure that the company comes back. But if for any reason it doesn't come back, the Act also pushes it to the official liquidation era. This new unit in the new ORC, it's going to be able to we can employ consultants to help us to liquidate or to manage these companies. But currently, we haven't set it up because we are putting up our strategy documents because it's a new office. So we are putting up our strategy documents for the new office. We have an organizational manual, an organizational plan, a strategy document to draw up our scheme of service, who should really be in this new office, and most importantly, a decoupling plan. Once we do all this, then this new office will probably be set up and you hear about it, because currently we just grandfathered about 127 insolvency practitioners yesterday alone, and we already grandfathered about 200. We're talking about 300 insolvency practitioners together with Garia that have been grandfathered. So we have a large pool of insolvency practitioners who are going to assist the official liquidator and the Registrar of Companies to handle this area, which is very new in politics, the whole administration of businesses. So we'll oversee administration, restructuring, and insolvency procedures of companies and other corporate bodies. These insolvency practitioners will have to present reports to us to make sure that they are in line. We'll also receive reports from agents for debenture holders, trustees for security holders, and auditors for companies in distress or insolvent situations to enable us to carry out corrective measures. There's going to be a temporary freeze on the rights of creditors and other claimants against distressed companies. We're going to provide for the development and implementation of a restructuring plan so that there's a better return for creditors and shareholders of the company instead of immediately winding them up. We're going to be carrying out research, commission studies, disseminate information, and provide public education, such as this one, in the area of insolvency administration. Most importantly, we'll maintain communication and liaise with international agencies such as INSOL, as well as the International Commission on Trade Law in the area of insolvency administration. So all this is in place, basically aimed at providing the ease of doing business and good corporate governance. Some of the key updates you need to know about this new act is we have changed regulations and articles of association and memorandum of association to the Constitution. Now we have a Constitution, and the Constitution, if you go into the Companies Act, we have 6 types, and it is all in the various schedules of the Companies Act. This new Companies Act says that you do not need to file a constitution right from the onset when you are registering. You can adopt or accept one of the constitutions in the schedules as your constitution. After the registration, we will give you a printout of your deemed constitution. But if you look at it, there are some bodies that would necessarily need a constitution, because in this deemed constitution, you don't really need to provide us with any objects, but you would need to let us know which sector you are operating in, because we need to inform people about the strategy of a company, maybe in a particular sector. We want to know the number of companies maybe dealing in mining or trading or whatever sector that is listed in our system. And so if you don't provide us any object clause, nobody will know what you are doing. But the whole idea was the committee of experts thought that if you are not a specialized company, they see the company as a natural person. So you should be able to do anything under the sun as long as it's not immoral and it doesn't contravene the laws of this land. And because you remember in the past, you could write so many, maybe 2 or 3 pages of objects. And they thought that we should just make life simpler for businesses. So that's why they said it's been sort of made a bit easy. It's not mandatory, but you would need it when you operate in, for instance, the banking sector, where you have another body that regulates you. The security, if you want to have a security company or a school, or or even if you have foreign partners, you need GIPC to regulate you. You would need a constitution. In that case, we call it the registered constitution, and you would need to provide objects. And that is how it is. But just bear in mind that all the rules governing the approval of names by the Registrar of Companies would still apply with regard to the name of any company. And it can, if you have a name that restricts you to a particular object, then you would have to stick to that. But if you have a name that is sort of generic, it's just, you just put it together, then as long as it's not qualified as one of these businesses being regulated by another body, then you can have any number of objects you want. Now, we've also changed the endings of names just to enable us to identify which type of business we are dealing with. We have new suffixes. It's been introduced in Section 21 of the Act. We have limited company or LTD. In the past, you used to have just limited, L-I-M-I-T-E-D. Please, if you registered in the past with your name ending with L-I-M-I-T-E-D, don't assume that is the same as LTD, because there are some public companies that had their names ending with L-I-M-I-T-D, but now in the new act, it's been distinguished. A public company is now public limited company or PLC. So please take steps to change the ending of your name if it's L-I-M-I-T-D and adopt either limited company or LTD. Publicly listed companies is now PLC or public limited liability company. All companies limited by guarantee is either LBG or ending limited by guarantee. If it's a public company limited by guarantee, it's PLBG or public limited by guarantee. If it's a unlimited liability company, it's a private unlimited liability company, to be PRUC, private unlimited company. If it's a public unlimited company, it's PUC, PUC. So these are the new suffixes. It's 6 in all. You have to find wherever your company fits. The age has been lowered from 21 to 18, and we don't require the minimum stated capital anymore, except you are one of those specialized companies like GIPC, where you have to have a minimum equity. But if it's not on any of those things, you can have any capital. In the past, it used to be 500 Ghana cedis. So you can choose whatever. Why? Because, and we've done away with the certificate to commence business, because in the past, you need to swear before a commission of oath that you have deposited a certain minimum stated capital in your account. And of course, as the registrar, we weren't able to confirm this fact. It was such a waste of time. So it was just done away with. So you just go ahead, download our forms. It's a form 3, fill in whatever you want to fill in. If you don't want to attach a constitution, don't deem and accept one of our constitutions, and that's it. We give you only one certificate now, a certificate of incorporation. No more certificate to commence business. We have electronic transactions to promote digitization. We have an official bulletin known as the company's bulletin. We're going to come out with these instructions on this bulletin before the end of this month, so that you will stop having to go to Ghana Publishing. Once we register you in this office, all the notifications that the general public might be interested in will be put in this bulletin. The code, the act specifically states certain specific things we're supposed to put in the bulletin. And so you can get all that information. We'll have it in both hard copy and electronic copy for a little fee. So you can download it from our website and pay a little fee for it. You get all the information you want. There's also a provision about the unclaimed dividends. And there are quite a number of companies that have unclaimed dividends. And the committee of experts thought that instead of these unclaimed dividends sitting in the company's accounts and then the company borrowing people's unclaimed dividends, after 3 months, you're supposed to open an interest-bearing account if you have unclaimed dividends. And if after 3 months, the shareholders haven't come for it, or those who are supposed to benefit haven't come for it, then you are supposed to transfer these funds to the office of the Registrar of Companies, who have also opened an interest-bearing account in both cedis and US dollars under Section 73 and 74 of the Act. We will manage it for 7 years and make sure, so the same bulletin is going to put up names of shareholders who have to come and get their dividends if it's due. And if after 7 years they do not come for it, then the law says that 50% is going to be transferred. And it's not the whole bulk of the 50% of the, no, in relation to every single person's account. So it's not like en masse, 50%, no. So if we wait a particular company after 7 years, nobody's coming, 50% of their unclaimed dividend goes to the government of Ghana, GOG, and then the other 50 comes to the ORC, interest-bearing account, to be used for investor education, research, entrepreneurial development, and advancement in company law. I talked of the suffixes, and you can see the various types of companies I talked of. So you see the private limited, you have LTD or limited. The form to use for a private limited liability company is Form 3. And you can find this in the second schedule. The form to use for a private unlimited liability company, that is PROC, or private unlimited company, is Form 3A. You can find in the second schedule. The form for a private limited by guarantee, LBG, or limited by guarantee is Form 3B. You can find it in the fourth schedule. A form to be used, a public limited company, PLC, or public limited companies, Form 3C, and is in the third schedule. Public unlimited liability company, PUC, or public unlimited company is Form 3D, is in the third schedule. And last of all, public limited by guarantee, PLBG, or public limited by guarantee is Form 3E, is in the fourth schedule. Another change is that accounting terms have been modified to conform to the International Financial Regulatory Standards, the IFRS standards, as adopted by the Institute of Chartered Accountants, Ghana. So instead of financial statements, we're saying that instead of accounts, income statements and not profit and loss account, equity shares instead of ordinary shares. And a major change is the auditor rotation. Currently, the Companies Act under Section 13911 is saying that all auditors can only stay on as auditors of any company for 6 years. After 6 years, they are supposed to be changed. So as they get into 6 years, at the AGM, you have to appoint a new auditor. And this old auditor cannot be your auditor for another 6 years. That's the cooling off period. And after that, you can appoint them again. The whole idea is to ensure that they don't just get too familiar with the company and give you the right advice you need. So we've put out this notice, and this notice was put out as far back as 2022. We extended it to December 2022. So from this point onwards, if you haven't changed your auditors in the over 6 years, please do that, because penalties and sanctions are being applied as I speak. So please make sure that you change them. We have changed, improved corporate governance and provided some professionalism by giving a qualification for company secretaries. And you find this in Section 211.38223E. I'm sure you're all aware how company secretaries were appointed in the past. People would just think of them on the spur of the moment and use their wives or their children or their drivers or even their gardeners, anybody at all that just comes to mind who has absolutely no knowledge about company law. But the Act has changed that. Now you require somebody who has the qualities of having a professional qualification or tertiary level education, at least having gone to school to study company law or practice and administration, or some knowledge of it to perform the functions of a company secretary. You can have a company secretary trainee who has held office under a company secretary for at least 3 years, or you can have a chartered secretary, a member in good standing, administrators or the Institute of Chartered Accountants. We can have, I recommend you to go for the barrister or the solicitor who is also in good standing with the GBA. Or you can have by virtue of an academic qualification or being a member of a professional body, you appear to the directors to be capable of performing the functions of a secretary of the company. Unfortunately, most people are picking this one. So they've still gone back to their old ways. Anybody who studied maybe in any university who has absolute knowledge about company law is being made a company secretary. Maybe going forward, we'll have to repeal this particular provision to make sure that we get the right people to do the job. So the company secretary has quite a bit to do, but most importantly, you assist the board to comply with the constitution of the company and any relevant enactment. You maintain the statutory books, you keep and maintain the statutory registers, the books and records of the companies, and you ensure that the statutory reforms and the returns are duly filed with the Registrar of Companies. With directors, it's also changed. In the past, you didn't need a director to consent to be a director. You could just appoint a director and that was it. But now, the director needs to swear to a statutory declaration that they have not, within the preceding 5 years before incorporation, been charged with or convicted of a criminal offense involving fraud or dishonesty, or charged with or convicted of a criminal offense relating to the promotion, incorporation, or management of a company that has gone into insolvency, or being a director or senior manager of a company that has become insolvent. And if the person has been the date of the insolvency of that particular company, and this director has to consent within 28 days after being appointed a director. And this is definitely different. You need to update all these documents when you are filing the registration. You have to bring us these documents as well. So you file it with your company secretary at the company's registered office, and they give a copy to us within 28 days. I'm going to stress on this one to keeping company register. The register of members is something we realized most companies do not even know about or even have. You can get this register from Ghana Publishing for now, but going forward, I think the office will have to put together such documents so that companies who need either could download it or purchase it from us, so that you can't keep a register of members. We found this out when we were implementing the beneficial ownership regime. We realized that when we're talking about companies keeping a register of members, and also in that same register keeping a record of their beneficial owners, we realized that they didn't have any. In fact, they used our register as their register of members. Can you imagine? So they'll rush here from when they do any changes, instead of going through the procedure and ensuring that it's filed at the company's register, they will just rush to our offices with their changes. And so we told them that that has to stop. Going forward, you need to maintain a register of members. You need to also make sure that you have an officer, a registration officer, whose job it will be to open up this register for members to, examine. And you need to have a specific particular address for members to be aware where this register is being kept, so that they can always go ahead and check if the records is being kept properly on them. Right now, we will come to the branch registers. If you have a company that has branches in other jurisdictions, please, it's important for you to keep branch registers. And you also need to keep copies of charges that the company might have, put on the assets of the company. It's very important you do that. And make sure that you register it with us as well, because especially if you have lent money to another company, people will just end up at a land title. And after that, they will never come or the collateral register, never register it with us. What happens is if the company goes into liquidation, we will not see that your company as a secured creditor and you lose out. So if you are a company secretary to a bank, please ensure that when you loan monies to anybody, you register the charge against the company's records in our office to make you a secured creditor. And that is something that I think you should all know. We also now have interest register. In the past, directors could be hiding behind, how do I say it, businesses would have their own interest in contracts that are coming before the company. And nobody will know about it. But now directors are supposed to disclose at directors' meetings and sometimes in writing, and it should be entered in the interest register, and they should state their interests in contracts or anything that the other directors need to know. And other directors can also inspect this register. It must contain the shares. We also must have a register of holdings of directors. It must contain the shares held by directors in the company or an associated company that the director benefits from. This is also new. So if you have an associated company, you are benefiting from it, the director has to inform the other directors about it. And you must have the register showing the particulars of directors and the company secretary, even including the substitute directors. Now, the resultant forms that you need to also know about, in addition to what I've already talked of, are the completion of the beneficial ownership forms, BO1, BO2, BO3, BO4, which is the new regime I said we have introduced, having to deal with the beneficial owner. I'll talk about it later on. The website you can get all these forms are www.rgd.gov.gh or www.orc.gov.gh. And we are now moving our forms from the old website. And that is how come we have both websites running parallel. We also want to let you know that all companies have to update their registration documents with us. If you were incorporated before 2012, I'm talking of what we dub the re-registration exercise. You have to update your information. To update it means you need all your members to have a unique tax identification number. You need to file your annual returns up to date. You need to update us with the beneficial owners of your company. You need to do this before we can, what we call, update you in the new system. And that is what we call re-registration. Once you're in the new system, then you can do the change of name, as I said, to end with a suffix, either LTD or whatever. Then you can also adopt the new constitution. You have to replace your regulations with the new constitution. And now the government has directed that everybody needs an NIA card. So we haven't updated the system yet. So we request for a copy of your NIA card. So you need to file all your annual returns, and financial statement is mandatory 18 months after incorporation and then yearly thereafter. And if it's business names, within 28 days after it's up for you to renew, you need to renew it. We have come out with a notice. We have over 500,000 business names we're going to strike off the register. They have never renewed since they were incorporated. They registered. And the business name law says the business name lapses after you don't renew it. And we are going to enforce it this year. So if you know you have a business name and you haven't renewed, it's now 60 Ghana cedis. It used to be 25. It's now 60. So please make sure you renew it. Otherwise, we'll strike it off the register. And the whole idea is we want accurate data in the register. Now, the BO regime is this. A beneficial owner is defined in the first schedule of the Act as an individual. That's the key. It's a natural person. It's not a company who directly or indirectly ultimately owns. And when we say ultimately, we want you to drill down to the ultimate owner who owns or exercises substantial control over a company or a person. So in such a scenario, this could be maybe a company limited by guarantee, because this doesn't have anything to do with a substantial economic interest. So that is it for that one. And then we come to the one who has a substantial economic interest, like somebody who is hiding behind a person. When they declare dividends, he gets the dividends. And that person is just a face. We are asking you to disclose who really is benefiting from a company, and yet the name is not appearing in the records of the register. But it could also be the legal owner that is the beneficial owner. We need to disclose that. Sometimes somebody is conducting a transaction on your behalf. We need to know who it is. Or there's a legal arrangement, or formal or informal, we need to know. So this whole beneficial ownership, Ghana signed on to it in the UK, and it's supposed to bring transparency and bring a level playing field so that you actually know who you are doing business with. And it's in this central register that the Act has asked us to keep. It's maintained in both manual and an electronic format. So the times you have to give us this information is during incorporation. If there's any amendment within 28 days, you have to inform us when filing annual returns, or if we require you to give us an update. And so, as I said, once you keep this register of members, you have to keep the BOs in this register. Within 28 days, you should give that one to us. Now, the people to give us this information is not all businesses. We don't require this from business names or partnerships yet. So for now, it's companies limited by shares, by guarantee, and limited liability companies and external companies. I've spoken of the times you need to bring it. And the information we basically want is the full name, any former names, your date of birth, mobile numbers, nationality, ID cards, passport numbers, residential, where you work, the nature of interest. So you have to give it, if there's a legal document or financial, security debenture, informal arrangement, giving rise to this beneficial ownership sort of relationship, we need to know. And most importantly, if you are a politically exposed person, you need to disclose that, because invariably or not, we are the troublesome ones. I am a politically exposed person because I'm entrusted with a prominent public function in this country, not because I want to be a politically exposed person. So what that means is that if my son is going to register a company, even though I have absolutely nothing to do with the company, he would have to disclose me as a beneficial owner of his company because I'm politically exposed, because the relationship is son. And the next slide will show you the kind of relationship. The thresholds, we've had to come up with some thresholds to help us not just duplicate all the legal owners as beneficial owners. So for companies in the high-risk sectors, such as the extractive industry, real estate, used car dealership, financial sectors, gambling sectors, if you have such a company and you're in that sector, you have to disclose all BOs who have a 5% interest. So 5% and above. Under 5%, you don't need to. But if you're a politically exposed person in any of those companies, you don't need any percentage. You need to disclose if you are a national. If it's a foreign PEP, 5% of that. And all other companies, we set 20% threshold. Because those selling maybe the market, they are not that dangerous, that you should not disclose it. They are just a simple person selling maybe used clothes or that sort of thing. I even used cars, yes, but maybe Bruni Wewu and things. I don't think that they're going to be doing money laundering and that sort of thing. So we said 20% and above for that. The whole idea is we just want to know who is really controlling the company. So if you see what the definition of a PEP, I fall in the first category, is either a prominent public function or government, judicial, military, any of these, or a senior political party official. You need to disclose. The immediate family we are talking of for close associates are children, grandparents, grandchildren, and business associates. And there's a particular provision you should be aware of. If you fail to provide this information, or you provide false or misleading information to us, you commit an offense, and you are liable on summary conviction to a fine of not less than 150 penalty units and not more than 250 penalty units, or to a term of imprisonment not less than 1 year and not more than 2 years, or both. And the penalty unit is 12 Ghana cedis. So we're talking about 3,000 Ghana cedis. So if you default in complying, this is the sanction. And we have put templates out to help you to be able to fill this thing. That's what I talked of: BO1, BO2, BO3, BO4. And the law also mandates us to formulate regulations and guidelines to help you implement it. And these ones will put out very soon. The board is overlooking them, and it will come out for you to go through. And I just need to let you know that under the Ghana Economic Transformation Project is being funded by the World Bank. We have a consultant that's putting together these documents. And so we're going to be leaving where we currently are very soon. We're going to be constructing a new office. We found land in Legon, and we're currently doing the design of the new office. And this is our new logo, as you can see it. We're going to become, this World Bank project is going to help us to procure a new software with efficient functionalities. And we're not going to be doing walk-ins anymore. If it is going to happen at all, you're going to pay more to walk in with hard copy documents. We're going to deploy this new software before the end of this year, getting to the end of this year around November. And it's going to be an online system, digital. You can sit wherever you are, log in into our system. There's a portal. You log in, you do everything online, you pay online, and we want to do this to reduce the turnaround time of our services. We're going to be sharing data as well. This new mechanic software is going to be able to sell bulk data to those who want bulk data. There's going to be a standard API for data sharing, real-time access. Banks that want to have this kind of facility can have an API with us at the point of registration. If somebody takes that, I want to save maybe with this particular bank, say Zenith Bank, once we complete the registration, the information will go to the bank, so they don't need to trouble us to give us searches to produce this information. We want to make it seamless. There is going to be an AI chatting capability to enhance the registration process. We're going to have a chat robot, voice and text, to help you, to assist you through the process. Maybe it could be even different languages. And then, Yahweh, Faha, is Ga, is ever, just to help those who are in the informal sector to try and do things themselves, not let the Guru boys cheat them. We're going to have an ability to flag companies with issues. We have quite a number of requests, because people have come to remove people as shareholders or directors without going through the right procedure. We're asked to flag companies. We have that capability. We want to use the mobile app for you to register your businesses by phone. And it's going to be exciting. We're going to be using the XBRL format. It's called the Extensible Business Reporting Language format for filing our financial statements and annual returns, so that we can actually come out with proper reports, statistics as well. Because currently what we're doing is we actually scan the paper and we're not able to extract the financial information that people would need. So we are coming up with this format. We're going to come with the renewing your businesses on your phone, the USSD, the unstructured supplementary service data for some of our services. All this is meant to promote the ease of doing business. We're going to integrate your email system with our system so that you will get text messages, and at every stage and every process of your application, you get information of what stage is reached. We'll give you SMS and all those things. And then we're going to, of course, integrate with Ghana.gov for your payments. It's going to be online. And we're going to be linking up with some offices such as the Intellectual Property Office, the NIA, which is going to be the unique identifier across board, metropolitan and municipal district assemblies for your business operating permit, Ghana Revenue Authority, Ghana Post, National Communication Authority, we want to validate mobile numbers because people are using people's numbers. You can have all shareholders coming with one mobile number, which is definitely false. We want to even try the judiciary as well, the judicial service, and the Bank of Ghana for the collateral registry. So we are going to be linking up with quite a number of businesses. But I'm sure you're going to be excited about this one. Before the end of this year, we're going to be coming up with a VVIP unit where it's going to be located here before we move to our new offices. The fees are a bit high, but the whole idea is we want to provide you swift service 24 to 48 hours. You should get your documentation done. And we'll have a call center as well. And I'm going to be there when we start. You pay a bit more. We'll try and have the bank at least a cage there so you pay your everything. They don't have to go and queue in the main this thing. And then I think to make life a bit easy for you. So basically, I think I've spoken a lot. The whole idea is we are trying to optimize and effect a new legal regime and providing you a quality service and ensuring that you are satisfied with us, and the business community also will have the ease of business we've been talking of. Thank you for listening to my long chat. Thank you.
Thank you very much, Mr. Ware, for this insightful presentation. As always, you've talked about the changes that has occurred with the coming into effect of the New Companies Act, which is now the primary legislation governing companies in Ghana and company administration. You highlighted some of the changes as the fact that there are new prefixes, which everyone is expected to make effort to change it to, because there were directives that everyone should change from their old prefix to the prefix that apply to their business. You talked about the minimum, the fact there's no minimum capital in the Companies Act for Ghanaians. You also talked about the fact that there are statutory qualification for company secretary. You talked about the fact that there's been a carve out of an office called ORC, and it has its own new registrar. And so we're happy to have learned this. You talked about the beneficial ownership. You highlighted the threshold that it doesn't require disclosure, but the overarching effect is that where there's an existing control, you still be required to disclose beneficial ownership. So I'm really happy to hear from you this morning. I would go on to ask questions from the panelists. I mean, there are questions in the chat box. So we'll take some questions. So we have Yao. We have a question. We say that if the object is not mandatory, as you said, your proposed business is not specialized business. Why is it that in registering a company, the company inspector is compelled to write an object for the company?
It's not mandatory if it's not in a regulated area. So if they are forcing you to write an object, refer them to the Act. What they want you to do is give them the sectors that you're operating in. So if they are troubling you, you can inform them that the Act does not mandate you to give an object if you are not in a specialized sector. And that particular box in our system is not, it doesn't have a mandatory, mark on it. So if you don't put an object there, what has the mandatory mark is the sector. So you need to indicate which sector you're operating in. That one they will ask you. And so if what you're saying is, I'll have to just make them understand that they shouldn't trouble people if it's not in a regulated sector. But if it's a regulated sector, they will trouble you. So I'll take that one on board and then let them.
The problem is that sometimes there's a gap, knowledge gap between the people who sitting at the computer and the lawyers. So you are compelled to disclose information even though the law is saying differently. And I think that's what the challenge is. Okay. We have another question from I think that question has been answered. Let's see. Is the combined register still a requirement under the new act? Also, what happens to the portal that we registered on for completing new incorporations?
The combined register is your decision to have a combined register. You can also have different registers. What is more important for us is you must have different types of registers. So if you're able to have a combined register, that takes care of maybe all the names of your directors and the changes and the secretary and the meetings and the shareholding and all that. That's fine. The important thing is they are the books that have to be maintained by the office. Yeah. His problem was what? Registering on the portal. Yes, it's still valid. If you register a company on the portal, it's still valid. It's been captured in our database, and so it's still valid.
Yeah, I have a personal experience about that, and it's quite efficient.
Like what?
No, registering the portal still works. That's what I'm trying to say.
Oh, that's what I was asking. Oh, okay. No,
yes.
there are challenges. Yes, there are challenges, and those are some of the reasons why we are coming up with a new software. For instance, to register on the portal right now, when it gets to the payment platform, there are issues. There are issues, and it's not too user friendly. And those are one of the reasons why, in fact, we did the evaluation of the new software. We completed it yesterday. And so we are really on course. We have gotten we were able to evaluate about 4 suppliers. And I believe that the best person will come up with a software that will make you all happy. So we are really on course. But you can at least download the forms from the website. You can try and register. If you have an issue, of course, there's a helpline. You can always walk into the office to complete the process.
Okay, there's a question relating to the qualification. Someone is saying that he agrees with you that the last qualification, there's a problem because such persons may lack core corporate governance knowledge, but may have administrative knowledge as company secretary by reason of the experience. Company secretary is now more than just administrative role, and the registrar of companies should look into that very well. So the person is picking on the last requirement that knowledge of or experience in company secretary should qualify to act as a company secretary. There's a question which is not clear, but I think I'm going to skip that one. There's a question about registration of loans at the office of the ORC.
No, you're not supposed to register loans here. No.
That's the collateral registry.
Yeah, it's not here.
So there's a question about the standard companies. Are they required to complete a BO forms, the standard companies?
Yes, every company needs to complete a BO form. Yes. Let me say the BO1 is the form that sort of gives you the list of all the BOs you're going to disclose. Then the BO2 is for a natural person. The BO3 is for a publicly listed company. We had to come up with a BO3 because a publicly listed company, it's almost impossible to determine who the beneficial owner is because the shares keep on changing, maybe on an hourly basis. And so all we ask for is a link to the depository where the shareholders' names will be. And then for the fourth one, the BO4 is for maybe a government body such as maybe ORC owning shares in a company or any of the ministries owning shares. Again, it's not a natural person. And so whoever heads that institution will be used as the BO, but it will have to be changed as and when that head leaves the place. So that's what the BO forms are all about. Yeah.
Just to get a follow-up to that, are we considering also having a BO form trust? Where it's being held through a trust. They would know that there are a lot of investment centers in the world, and the actual shareholder might not necessarily be a company or an individual, but it's held to a trust which is undisclosed. So are we considering the requirement for BU for trust, whether incorporated in Ghana or elsewhere?
Yeah, it's being considered. It's being considered by the consultant who is assisting us with the BO regime. And so, because they know that there's quite a number of trusts that carry huge sums of money where there's a lot of money laundering. You know, our scenario in Ghana, we do not have legislation regulating trusts. So that's why it becomes a bit tricky. But I do know that the consultant is ensuring that we have maybe a form to take care of that. Yeah.
Okay. There is something in the income tax law on tax, but it doesn't go beyond company law. It's just on the tax point of view. So, and I think it's predominantly governed by the rules of equity and succession. And so we may have to look at that area someday. So let me take more questions. So when registering a company limited by guarantee, do you need a letter from an auditor or you have to provide their details? And
No.
the second question, what's the plan to make it easy for young people to incorporate startup companies?
Yeah. For a company limited by guarantee, you will still need to get a letter of consent from an auditor. For startup companies, I would prefer they register a business name. It's not too difficult to register. The forms are easily downloadable. And it's just a name, what the objects, your NIA card number. For the business name, you need to provide objects, mind you. And then you sign where your residence, and it's just 100 Ghana cedis now to register a business name. You don't need much. You don't need directors. You don't need a secretary. You don't need auditors. So for startup companies, the young guys, they can start off with a business name. As the company grows, then they can move on to a limited liability company or a partnership.
Okay, all right. There's a question about if you can throw more light on the VVIP services,
Okay.
whether we can have we can avoid people having to queue to file financial statement and all that. I mean, if you could just give us a highlight in respect of VVIP services.
Okay, so it's possible that with the VVIP service, when it gets to filing of annual returns, we might have a bit of a problem because it's currently, scanning manual accounts. So we'll just have to dedicate, a particular data entry clerk to do that kind of thing. Because I know that that is a big problem for people now. As long as you're paying a little bit more, you don't get that many people being there in the first place to get that kind of service. So we believe that it will be faster service than if you had gone to the front office. But the more appropriate one would be, when we have the software that wherever you are, you can just file your returns without coming into our offices at all. And use the XBRL format where we'll have the forms, and the ICH is going to help us with that. So you input the figures into those fields. You don't need to scan anything into our system, yes. And then we can extract that and come up with the various, you possibly PDF the financial statement itself. So that is what we are looking at. So for now, they should just bear with us. At least we are trying to improve what we currently have. Yeah. Just bear with us on that.
All right, thank you very much. I know Parliament has passed the fees for you.
Yes.
And the VVIP is also covered. What I'm not sure, has it started or just to start?
I don't want to do it until the system is stable.
Okay.
So we are currently migrating the e-registrar to the G Cloud environment. Once that is done, and then I'm not going to have downtime and the system is not working and all that, I can't take somebody's money. I've promised you 24 hours and then the system is down. No, that's why I haven't started it. We are going to refurbish the ground floor. If you know where we used to have the re-registration unit, we are refurbishing that and we'll block entrance from the front office. So you have to enter the VVIP from behind, where we'll set it up to your comfort and make sure that we give you the service within 24 to 48 hours. To get a company registered in that kind of unit is 1,000 cedis alone to go into that place. And then for a business name, I think it's 400 cedis. So that would definitely, so to register a business name, there will maybe cost about 5 100 Ghana cedis to register a business name. And the company will be a bit more. So that it's serious. You come there. It's not a matter of we wasting your time. Within an hour, you get your certificates, your profiles, and you're gone. So that's how we want to do it.
Mr. Ware, thank you very much for that effort. But my subsequent question would be, if you have the VIP services, wouldn't that incentivize those who are not patronizing VIP to rather be in a long queue before they're receiving those services or getting their certificate or getting their documentation? Because then the focus will be on the VIP because it's generating more money for you.
No, that's not it.
It won't happen.
No. We'll still continue with our services as it is right now. But there are some people who want expedited service, and you should give them that opportunity, because you're going to get in that place. You have a lawyer, you have about 2 data entry clerks, you have a company inspector, all seasoned people to help. Because sometimes when people come, they don't even understand the transactions that some of you guys are presenting. So you need that kind of quality staff there to give you the help you need.
Anyway, let's go on with a question. There's a question about auditors as to whether it is okay to allow all companies to change statutory auditors by every 6 years when they don't have any business to do with the public, if they are privately held business. Shouldn't the focus rather be on certain sectors such as banks, capital market? Why would a company in Boboloshi selling maybe tiles required to change the auditors? Isn't there a problem? Or whilst we're talking about amendment, isn't that an area we should look at? This is a question from someone in the public.
Well, this was the decision of the parliamentarians. This particular provision came in at the time when most of the financial sector was having issues with the closure of banks and all that. And they brought it on to the private companies. But I think you know that the financial sector already has that provision. With the banks, you do not last more than 5 years as an auditor. So it's just been brought into the private sector to ensure that there is no familiarity between the auditor and the company. So this was a specific provision put in by the parliamentarians. And so you realize that it's not in the memorandum to the act. So this is what Parliament wanted. So that's what we have to do. So we have to comply unless it goes back and Parliament rescinds that particular provision. But for now, it's not done that yet.
Okay. During the COVID, you issued a directive about holding of annual general meeting online, virtually, and a requirement to make a disclosure to you. Is this still enforced?
Yes, it is.
Well, could you throw more light on it for us?
You just write to us informing us that you want to hold your AGM online, and just to assure us that the members are all in agreement, because you don't want to, disadvantage any member by that. That is all. And we will give you the approval.
Thank you. Thank you very much. Let's move on to the next question. You talked about the BU threshold. Is there any guidelines on the BU threshold so that the public will be aware of? You talked about 5% threshold. If you could tell us a bit much more on those thresholds.
Okay, so I said that if you have a company that is in the high-risk sectors, such as the extractive industry, gaming, commission industry, used car dealership, banking, and financial sector, what we're saying is that the threshold is 5%. So if you have a beneficial owner who has a controlling interest in regard to shares, just 5% of the shares of that company, you have to disclose that person. And we said that if even in that company scenario, there is a politically exposed person, that one, there's no percentage, it's 0%. And we said that a politically exposed person for an external company, we said the person should have about 5% interest for the threshold. And we mentioned where it's not any sector per se, any ordinary business is 20%. But we are going to put out the guidelines to help you. I told you we gotten DFID. It's now GIZ, yes. They are helping us to put out the practice guidelines And again, we'll put that one on our website so you can download it and it will help you.
That'll be very helpful to
Okay.
the users of the company law. There's also a question about whether what steps government is taking to improve compliance of the BEO requirements in Ghana, and what roles businesses can and civil societies can play in that.
Well, for now, I think government has really assisted us a lot. We are going to come up with a new software. We will sit with CSOs who have helped immensely to bring us where we are, to ensure that we review the BO disclosure, as well as making it accessible to some of them. Because the whole idea is we should have a software that you can just access the BO data on companies upfront. What we currently have, when you're accessing it, you have to practically access all the information at once. And I think that is wrong. So we will be still dealing with the CSOs to ensure that we do things that will make them happy. But for now, it's at least it's on the portal. It's we are collecting it both electronically and hard copy. So they can request for it by requesting a search, paying for it, or go online, pay for it, and get it.
Okay, so those who normally would disclose their BU are also concerned about data protection issue and who has a right to get that information. And that is why in some countries you would have people setting up trust. So how are those disclosing the information protected? Because we live in a cybersecurity environment where people are scamming others, people are looking for other people's residential address. So what kind of protection do those, beneficial owners actually get from complying with your law in terms of data protection?
So we don't disclose as much as is possible residential addresses and date of birth. But any other one we will disclose unless whoever feels threatened by maybe a gang maybe wants to kill him or something, they can write to the registrar and plead for some form of protection that is different from what we are giving any other person. And mind you, by the very nature of a BO, it is supposed to be disclosed. So when you ask for, like, cover my information, it's going to be a bit of a problem for us. The whole idea is it should be disclosed. But if your life is in danger and there's enough evidence and proof, you have to prove that to the registrar, then that kind of information will not be given out, to be known only to the competent authorities who should have access 24/7 without any cover. So we do protect them by not disclosing their residential addresses and their date of birth.
Okay, thank you very much. So what would you say has been the impact of the disclosure of BUs since we started complying? There's a question from someone asking whether you think that there's been an impact, because the essence of this is to curb corruption, is also to fight counterterrorism and all that. From the government point of view, would you say that there's been an impact since we started having the BU disclosures?
I guess at this point, I cannot be able to really show what kind of impact it's had, but definitely it's made company secretaries more compliant. They ensure that they disclose this information to us before we can go ahead with anything. We are going to be coming up with a collaboration and verification of the data that is provided upfront, because at that point we can't really tell whether it's accurate, or because we are relying on your honesty. We cannot confirm whether it's truthfulness that you're giving to us. But I told we're going to be doing collaboration. For instance, if you come and disclose to us, and it happens all the time, you can see clearly that this person is lying because they don't want to go and pay maybe the GIPC loss. They will disclose the Ghanaian as the BO when they should be disclosing the foreigner as the BO. We try our very best. They come back and tell us that, please, it's the Ghanaian that is the BO. If we do collaboration and we go to the bank and we see that foreigner being the main person signing, we will kickstart the penalties and sanctions and we'll make somebody a scapegoat. Then maybe we'll be able to see the effect. But currently we haven't started that yet because we are now collecting, the collaboration is now getting underway. So I can't say whether it's effective now, but at least from the side of people being eager to disclose, it's going very well.
I agree with you that it's too early to assess because
Yes.
we just started the process. So we have to wait a while to see the impact. So I agree with you entirely on that point. There's a question about the minimum capital requirement for Ghanaians and foreigners. If a Ghanaian has a JV with a foreigner, the law is that the Ghanaian must have a minimum of 10% equity.
Yes.
And the Ghanaian is not required to contribute the same capital. But it looks as though your system is programmed in a way that if the foreigner brings in 200,000, the Ghanaian is required to pay a proportional amount of that percentage that he holds. And that is going in contradiction to the company law. I don't know whether it has come to your attention.
It has, but it was an error. That was an error.
So has it been corrected?
I think it has. It's been deployed now. What it is that what people were rather doing was they were rather taking a percentage of the foreigner shares, which they shouldn't. If the foreigner owns, even if the foreigner owns, say, 50% of the shares, and it's a joint venture, and it is not trading, the foreigner's equity alone has to be the full $200,000. What was happening was you find Ghanaians sharing in that $200,000 because it talks of the minimum foreign equity. It didn't talk of just the equity. So the software developers, I think they got it wrong. So the Ghanaian can have, if you say you own 50% of the equity, then you should also cough up $200,000 because the 50% of the shares, that minimum equity for the foreigner has to be paid up. Do you understand what I'm saying, Theophilus?
Yes,
So
yes, I agree.
If you choose to have a higher percentage as a Ghanaian, you might end up paying a bit more than you normally have paid. But because whatever percent, if it's 70%, the foreigner's equity should still be the same minimum equity that the GIPC rule said. But I know there was some message at the top that was, so we informed them about it, and a new model has been deployed. So please get back to me if that same thing is still happening, because that was a technical hitch. It wasn't something we're doing to contravene. Yeah.
I was thinking that if you have a JV with a foreigner, and the foreigner has 90%, and he's contributing $200,000, that can be for the foreigner. The Ghanaian can have that 10% for even 1,000 cedis.
Sure. Sure. But you see, what will happen is, that $200,000 should not be fixed, because you realize that when you do the percentage, you put the whole capital together, you put 90% for the foreigner and 10%, and the Ghanaian just has some 1,000. The foreigners' equity, some will come to the Ghanaians, and the foreigners' equity will not remain a minimum of 200,000 anymore. So you have to work it out well. Just make sure that when you put all that capital together and you do the percentages, 90% of that total stated capital should be 200,000 and above for the foreigner. Just make sure.
We will take this offline.
Okay.
We'll take this offline.
Okay.
All right. Any question? Do we open for my colleague? Do you open for some others to ask question or not? Let me see. If you can talk to us about the amended constitution, the registered constitution, and the standard constitution.
Okay, the standard constitution, we have all the 6 types and the schedules on our website. We have done the prototypes for you. So even though it's in PDF, you can download it and convert it to Word. And the sections, I think 1 to 10 cannot be touched, because it deals with the fact that it's specific provisions in the Act that defines the type of company that's a company limited by shares, and you can't transfer your shares, that sort of thing. But all the provisions after that, you can amend it to suit maybe you had your regulations, it's allowed. And being the first constitution, I normally would like at least either the back is signed by all the shareholders or the resolution that proposed for this new constitution. I can have all the shareholders' names and their signatures because that's the first constitution of the company under Act 992. Okay, so if you're a company already in existence and you want to adopt a new constitution, as we are requiring for you to do. But if you are starting a business and you want to have a registered constitution, the same thing, you can download one of the constitution and then let it conform to your requirements.
All right, thank you, sir.
Yeah.
I know you're also responsible for the Insolvency Restructuring Act, and it's come true by your tireless effort, and we have that law passed. I'm very much aware that you have been doing insolvency in this country, liquidation, official liquidation for a while. There's some school of thought that think that once we have this new Insolvency Act, any individual registered or licensed by GARIA with approval of the Registrar General or obviously ORC, Registrar of Companies, can do official liquidation. How true is that?
You can, you can. Now you can do official. If you are an insolvency practitioner, you are licensed by GARIA, and you are licensed in our register of insolvency practitioners, you can't do official liquidation. Nothing stops you, except that people don't want to use it because your fees are too high. They still want to come to the official liquidator because we don't charge that much. But we are going to be setting a minimum or a maximum that you can't go beyond, because sometimes you can have some charlatans who will just rip the company of the little money from the assets. So we'll have to moderate that as well.
Okay, thank you very much, Mrs. Ware. So the question about is there duration of a company after incorporation to wind up if it fails to commence business? Is there any duration?
You say, is there any duration for what? A company to wind up?
After it has been incorporated and it fails to commence business?
No, there's no duration. I mean, the point is, if you realize you incorporated and you haven't carried on any business, the Act allows you to inform us to wind you up. We call it dissolution without full winding up because you never commence business. So there's no duration. No.
And there's a question about how can a private company be converted into a public company?
Okay, so it has to be by a special resolution. The shareholders would have to agree to the conversion. And not only the special rules, they'll have to also change their constitution from a private company limited by shares to a public company. So with that, our system will be able to convert you from a private company to a limited.
Okay, thank you. Should we expect any extension of time to file annual returns, like an extension of time for this year?
We have given out a notice. Now, it's good you brought this up, Theophilus. We are going by the Act, which stipulates that 18 months after incorporation and yearly thereafter, we looked at the end of the financial year for companies, and most of them is March, and we looked at auditors, wasting time. So we gave up to 30th of June. You should have at least, if your financial year ends in March, you should have at least filed your annual returns. But we are coming up, we used to have a penalty of just 600. Now the Act says that each day that the default continues, if you do not file your annual returns, it's 300 Ghana cedis. It's 25 penalty units, which is 3 each day. And it's not just the office, it's the officers as well. And we are going to implement it. So we've put out notices that company secretaries and directors is 300 Ghana cedis for each day the default continues. Yeah, it's very punitive. So I've put out that please, people shouldn't waste time with, at least if your financial year ends in March, by June, you should have filed. If it ends beyond June, by December of the same year, you should have filed. So have 2.5 years.
All right, so from what you're saying, I'm getting the impression that you are going to, the requirement to file the returns is per your financial statement, when your financial statement ends.
Yes.
So if it is by June, it means that you have a number of months to file.
By
So it is
December.
not.
Yes.
So in the past, it looked as though it's blanket for every company. You have to
No,
file
no.
by.
We are working on. We're changing all that.
Okay, okay. That's a good initiative on that point, because that is more consistent with the law. So let's go to the issues about penalty regimes. Penalty regimes under the Companies Act. Are we going to see company being penalized for not complying with notification per law?
Yes.
You're required to disclose within 28 days. You've never done it.
Yes.
You're supposed to.
Yes.
Are we going to see that happen?
Yes, but you see it in the new software because it's going to have that functionality to even alert you that, for instance, you should have had a secretary by this time. Maybe a secretary has been removed. The law says within 6 months, you should have a secretary in place. If you don't, the penalty starts rolling on. This particular software, we don't have that functionality, but it is going to happen. So don't let's wait till we get to that time. Okay. Auditors, for instance, it will alert you that your auditors have to be changed. Things like that.
Okay. Yeah. So I know you're doing very, very well on that front with the changes, with the support of the IFC and World Bank and all that. But what about issues about automation, where we need to sit in our office and incorporate a company, file returns, lodge? I mean, when are we going to get there? Is it anytime soon?
I mentioned it, Theophilus. I said before the end of this year, we'll be deploying a new software that will do exactly that. Where you
maybe I missed that.
Yeah, you missed it. I talked of this new software. I told you the fact that we've gone to do the evaluation. We're going to get a software developer very soon. And it's a beautiful thing. I talked of all that. Where you don't need to walk into the offices with your forms. If you do, at best, you're going to have to end up paying more. You have the opportunity to even register your business from your phone. I talked of all that.
That's good. That's the good news. I'm sure my colleague might have also, maybe they didn't hear it well. So
I talked of all that.
Good.
Before the end of this year, we are hoping, say around November, we should have migrated from this current software to the new one, where you sit at home. You don't need to come here. In fact, we are pushing for that. Because if you go into the Companies Act, after it was passed in 2019, they said 5 years after that, we should go fully online. And so we are pushing for that.
That'd be very helpful for us, company practitioners. Thank you so much for making time. We are really happy to have you. Would have loved that was in person, but as always, you're always responsive to us when we call you. Your knowledge is tremendous, and we're happy to have learned under your feet. I'm sure our members or participants on the call are happy to have listened to you and have their questions answered. So you talked about the fact that online system will be up and ready by end of the year. You talked about the fact that a critical one is the fact that returns are due by 30th of June this year. The fact that the software is being operationalized to penalize companies if they don't comply. So we are moving towards a very compliance environment, and that's a very good one. So I'll give you a final comment to the people, then we will close up.
Okay. There are quite a number of questions in the chat that you didn't mention, so I'll take my time and answer it for them.
Okay.
Because I realized that quite a number of people have asked questions. You couldn't mention that. But basically, I just want to end by saying that we are not really interested in penalizing people. We are more interested in getting accurate data. Because at the end of the day, we want a register that people can rely upon. I've realized that people also are too eager to let other people do things for them. So you find these guru boys, you give them money, and they will sign your signatures. They will do all sorts of things without even your knowledge. Well, what that means is that one day they can come and take you off even as a shareholder or as a director. Because we started using the NIA card, I'm seeing so many errors, like they're trying to forge people's signatures, and I have to prevent the approval because I will ask them to take the documents to the people themselves. And when I call the people, they look very stupid that they gave their money to do something for them. So I'm just pleading people should take responsibility for the information they give the registrar, because actually there are provisions in the Act where you can be penalized for giving false information. We haven't really, activated it, but if we are pushed to, we'll do it. If you are a company secretary and you're a lawyer and that is fantastic. But I would advise that you go for professionals to help you to register, if even you don't want to do it yourself. Don't use the Goro boys hanging around our offices who rip you of money and also not do the right thing. The fees, we've pasted it at the frontage so you don't let anybody rip you off. We've also put it on the website so you can go there and go and get information on the fees. Recently, somebody charged somebody 800 Ghana cedis to register a business name, which costs only 100 Ghana cedis. Why? Because the people will not read. This, if I go, we bring online, and Ghanaians will not sit down and use it themselves. It will be so sad, because you make a Goro boy rich. They will tell you anything and put garbage in the system. So please, that's my advice. We want to make it easier for you to use the system, but use it yourself and make sure that the data is accurate. Because when it's credible and it's accurate, and then we give out that data, it promotes, good governance in Ghana, and Ghana becomes a better place. We'll be more trustworthy than just having wrong data in our system. So that is the end for you. I'm glad you gave me the opportunity. My doors are open. You have my number already. If you're having any issues, please do not hesitate to get in touch with me, and I'll see to it that the right thing is done. Thank you.
Thank you very much, Mr. Ware. We are very grateful. On behalf of the Executive Council of the UK Chamber of Commerce, I'd like to thank you for making time to join us today. We are really grateful. And at the right time, we will contact you to express our profound gratitude.
Okay.
Have a blessed week. And thank you, everyone, for joining.
Okay. Bye-bye.
Bye-bye.